give me your plate.
Yeah. Yeah.
Good. Here, give me all this because we're just 8 different kinds here. And that's a dirty for later?
These are pajamas. These are clean.
Okay. So, when you get done eating, then you have IXL and that's it?
Yeah.
You finished English, you finished everything else. Finished math?
Yeah.
What else did you finish?
Civic.
Finished it all. Okay.
Yeah.
So you just have IXL in here for what? English or
Math.
keep that there when you get done eating.
Take him out from there.
Hopefully tomorrow or the next day we'll all sit and have dinner together. Okay? Why are we playing games?
You're not.
You are. You're not. I'm trying to give you a chance, Ronan. I'm trying. I'm trying to let you have an opportunity, right? To be honest, to be trustworthy, to do what you're supposed to do, right? Right? You don't want that and you don't want all these things, well then that's fine. But if you want to have all these amazing opportunities and things like that, then at least be honest. Be honest to yourself, be honest to me, and do what you're supposed to do. If every time you have homework on your Chromebook and I give you a chance and you lie about it and you're being sneaky, I'm not going to continue to do it. But I'm giving you a chance. Look at me in the eyes. And you're caught and you're mad. It's the same thing, but a different day. So that's fine. So you can just do your same stuff like every other day. pajamas? Are those them right there? Do you hear me? Oh, here we go. Back to this, Ronan. Where you can't talk, you're a middle school boy, you want to do all these things, you want to do chess, you want to do things, but you can't talk because you got caught being dishonest. Okay, well, that's fine. I guess I'll just keep giving you more chances, Ronan. Every day, a new chance for Ronan. Even though Ronan doesn't care, he doesn't want to be nice to anyone. Oh, let's let Ronan do this. Oh, let me bring Ronan some food because I think he's going to have a good night. Oh, let me do everything for Ronan. Okay. Oh, but Ronan can't talk because he got in trouble because he got caught. It's like, give me a break. Start owning up to what you're doing and then try to fix the problem like we keep telling you.
Now publishing January 25th, 2022. It's a new day, right? Right? New day. Mad at yourself because you get caught. You get done with it. Move on with your day. You have another good day. Just trying to give you a better for you, right? Clothes. There's some breakfast. Are those dirty? What? Are they dirty or not? They're what? I know, you didn't wear them. Are they dirty or they're clean? Then let's come back over here. Grab clothes.
Good night.
Now publishing January 26th, 2022.
You ready?
You have to go to the bathroom and then you can divide Excel, right?
Yeah.
So you got, you go to checks today. So,
Cheers. Let's go.
no, I'm gonna take that. Okay, you get over here. Okay, I'm gonna give you those. And you just done? Percentage in. You actually working on it?
Yeah.
Okay. Are you searching up other stuff while you're supposed to be doing this?
No.
Okay. This is gonna be it. I'm gonna come get it right before we go. Is that the only one you have to do?
I do a couple more after this. Okay, what percentage? 78.
Alright, the top one?
No.
Alright, you get my plate.
to bed?
Oh, no.
Clean up your room? No?
I clean up over.
I think your was nice, got your stuff together. And we'll brush your teeth, and then I'll have the dog come out of you. So,
Alright. Can I get my stuff?
Alright, let's go. You're over there. Let's go. Let's go. You can go with the girls.
They're good because, as a couple, they said, the person is taking diagnostics.
Yeah.
Because it's a cover up because they don't want to embarrass the
Doesn't
person.
matter, yeah.
Yeah.
Doesn't matter. Everybody's probably gonna, you could be out. Like, if we decided, we could say you're not going back to school.
Yeah.
So, like, there could be a lot of people now being out.
Alright.
So, hey, don't put your stuff out. No. How's it going?
Good. Alright, thank you.
Doing soup and
Okay, thank you.
all right.
Okay, good night.
Good sleep. Good night.
Now publishing January 27th, 2022.
Morning.
Good sleep?
That's okay.
Yeah. Want to go to the bathroom?
Yeah.
Let's clean your bucket out. Let's put these in here. So it should be together like that.
Yeah.
Did you that in the morning, okay? Because you have plenty of time, right?
Yeah.
Welcome to your homicide.
Not yet.
Pajama?
Yeah.
You just cheated and you're in bed?
Yeah. Yeah. Two bookmarks for you. Alright.
Now publishing January 28th, 2022.
Morning. We should go to the bathroom. Do you need to take a shower today, or you can do it tonight?
Yeah, tonight.
Let's go to the bathroom. So you do it, can you make your bed first?
Yeah.
Clean up like your space here? You don't have too much that's clean up, right? So if you make it look nice, it's a good thing, right?
Yeah.
You have a good day?
Yeah.
Friday, right?
Yeah.
Having fun on Fridays?
PE in the morning. For last time until another 6 weeks because it rotates every week.
Okay. Okay, so what are you working on right now? Because you said you were finishing the IXL, right?
Yeah.
Okay, so what are you working on right now?
Seeing if it shows up.
What?
Seeing if it shows up.
You're doing IXL or you're not?
I am.
So what percentage are you on then?
46.
What's going on?
Bad.
Why?
The pounds are not. I don't know.
Almost done. 66, right?
Yeah.
It's dirty.
Yeah.
Alright. Why don't you grab your clothes really quick so that you have them on? What's wrong with the problem?
Nothing wrong with most of this. Hard to go through.
Okay.
So you're done now, right?
Yeah, no thanks. I'll be blessed.
Okay, how much do you have of that?
I have 2 vocabularies.
Okay, I'm gonna come in and grab that in a couple minutes and have you get some of those shells.
Okay.
Okay. Okay. Alright, why don't you leave the stuff in here? I'm gonna have you get shoes.
No.
Your shoes are right there.
Yeah, I need to change my shirt because I brought this morning. So.
Can you tuck it in?
No, it's not gonna be big.
Okay. So.
This is Megapony's room. Megapony room. Yeah.
Well, we adopt your bucket.
Let's go upstairs.
Okay.
Maybe later you can see my class. Yeah, I'm trying to. Maybe you can see my class later.
All right, thank you. Does the state have any additional items to publish?
We don't, Your Honor. At this time, the state would rest its case.
Okay, ladies and gentlemen, that concludes the state's portion of the case. The state has rested. There are some things that the court needs to address outside of the presence of the jury. So, Mark, if you could escort the jurors into the jury room, and I'll let you know when we're ready for you. All right, everyone may be seated. Does the defense have any motions?
Judge, at this time, we're going to move for our first judgment of acquittal. Essentially, obviously there's 3 counts here. The aggravated child abuse count has 5 different ways that it can be proven by the state. Either aggravated battery, willful torture, maliciously punished, willfully or unlawfully caged, finally knowingly, willfully committed child abuse, and in doing so caused great bodily harm, disfigurement, or permanent disfigurement. The state in this case, I think, has failed to prove that Mr. Ferreter willfully, intentionally inflicted any physical, mental injury that resulted in great bodily harm. The terms great bodily harm, permanent disfigurement, these come from the aggravated battery statute. There has been, as far as I can recall, no testimony that the child suffered great bodily harm, which means distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises, which were also not presented. Likewise, there's no testimony that this child was in any way disfigured. Aggravated child abuse is committed through other ways as well, of course. Malicious punishment is reserved for certain types of cases. In Florida, Wheeler v. State controls in this district. It's 203 Southern 3rd 1007. In that case, the rule that comes from that case is that great bodily harm or permanent disabilities or disfigurements are what demonstrate actual malice on the part of a parent and not merely a momentary anger or frustration. So the state, I think, has failed to prove actual malice. Malicious, there's a definition for malicious in the jury instructions. Wrongfully, intentionally, without legal justification or excuse. Maliciousness can be established through circumstances, and one could conclude that a reasonable parent could have engaged or not engaged in that conduct, depending on those circumstances. I think
in a motion for JOA at this stage, doesn't the state get the benefit of all favorable inferences? And so if I were to buy your argument there, at this stage, I would have to conclude that they have established malice.
Well, I do think that I think actual malice, though, under Wheeler, is that it's not any sort of a momentary anger or frustration. It's discipline that results in great bodily or permanent disabilities and or disfigurements, or demonstrates that the actual malice on the part of the parent was not momentary anger or frustration. So I don't know that we have any evidence of that. I haven't seen any evidence of that. What the state is essentially relying upon, factually, from that perspective, is moments where he comes in, he's yelling at Ronan, and those interactions that we saw this afternoon on the video, those fit more frustration and anger, if anything, but not great bodily harm.
But we're talking about malice, and we're talking about intent, right? I mean, that's the purpose that you're making this argument at this stage, right?
No, well, I'm going under the 5 ways to prove child abuse. Of them, I'm going through them. So I'm saying it's not aggravated battery. I'm saying it's not malicious, because we don't have great bodily harm. I also believe it's not torturous. I don't think there's any facts to go to torturous. And I think that the closest call here would be for the state is caged.
So you're trying to convince the court at this point that no jury could ever find that being confined in a 8x8 room or box, however you want to refer to it, that no jury on earth could find that to be torturous? Because I really have to find that no reasonable jury could conclude that that was torturous under the facts that have been presented. Again, which is why at this stage the state gets the benefit of all favorable inferences. Is that the leap you're asking the court to make at this point?
So torture involves extreme or sadistic conduct, which is absent here.
Well, I'm going to push back on that. I don't know that it's absent. What I believe is that there's certainly enough for a jury to determine whether it's torturous, evil, or sadistic. I mean, the video displayed many repetitive instances of the father coming into the room, his son snapping to attention in demonstrable fear, a repetitive, consistent berating of the child. it seems to me, and I'm not judging the facts one way or the other, I'm just merely determining whether they meet the standard at this point so that they can be passed along to the jury to make that determination. And it seems to me that a jury could conclude that this is torturous and that it is something done with evil and evil intent and malice. So move on from that, because you're not going to convince me that no reasonable jury could conclude that this is a torturous event here in the life of this child.
Well, in terms of the other elements, you have the argument was malicious, and in that I want to also draw the court's attention to Wheeler, which I gave the court the cite, but there is a clear difference between a parent's discipline and something that goes beyond and results in great bodily harm to the child. So I don't believe we have that here.
Okay, so let me read to you a provision that comes out of the case of Slocum versus State. That's at 757 Southern 2nd, 1246. And I'm quoting from that case because I think the part that I'm going to read is apropos to this. And just bear with me for just a second, Mr. Wahid, while I get to it. The court said, and this is out of the 4th District Court of Appeal, which is the court that obviously handles direct appeals from this circuit. Regarding another conduct element of aggravated child abuse, the dividing line between permissible punishment and malicious punishment is not always easy to draw. A defendant maliciously punishes a child if the punishment is imposed wrongfully, intentionally, without legal justification or excuse. The element of malice requires evidence that the defendant acted with ill will, hatred, spite, or an evil intent. And then the court cites the Gaylord decision where that court made this statement: the determination that a parent or one standing in the position of a parent has overstepped the bounds of permissible conduct in the discipline of a child presupposes either that the punishment was motivated by malice and not by an educational purpose, and that is, was inflicted upon frivolous pretenses, that it was excessive, cruel, or merciless, or that it has resulted in great bodily harm, permanent disability, or permanent disfigurement. And I think that recognizes that the great bodily harm, permanent disability, or permanent disfigurement is only one aspect of how you get to ultimately a conviction in an aggravated child abuse case. But the point I want to make here, and then I'm going to switch to one other case, and I'll let you have the floor back. And this is the Tate versus State decision. And I'll give you that site. That's at 136 Southern 3rd, 624. And this is what the court said in Tate, which gives me great pause in terms of the motion for judgment of acquittal here. And it says, Tate suggests that the state failed to prove that Tate intentionally abused HR, which is similar to what's being argued here. Because direct evidence of intent is rare, and intent is usually proven through inference, a trial court should rarely, if ever, grant a motion for judgment of acquittal on the issue of intent. And they cite a number of cases holding that intent is rarely susceptible of direct proof and is almost always shown solely by circumstantial evidence. And this picks up with what you said. Where reasonable persons may differ as to the existence of facts tending to prove ultimate facts or inferences to be drawn from the facts, the case should be submitted to the jury. So that's why I asked the question the way I did, is because if you concede that reasonable jurors and reasonable persons can disagree about what they've seen on the videos and what those videos mean, then that presupposes or actually mandates that I deny your motion for judgment of acquittal at this point. Do you at least agree with that argument?
Well, generally, yes. My only pushback on that would be that, unlike, I think, in some of the other cases that you've cited, and I've read Tate, just reading the case, what I think is different is here the jury has, and the court has, not just the video, but the audio. And the audio has the words from Mr. Ferreter himself. And you can see and hear in that there isn't it isn't malicious, that we're in the sense that ill will and no educational purpose. It's quite frankly the exact opposite. What you see and hear is that he's saying to Ronan that you did something wrong, and I'm trying to raise you to be somebody who's a good kid, not someone who is out there doing things that aren't good for himself or others, and you're not going to, you're going to go nowhere in life, and I want you to go somewhere in life. And there was some clips shown today where he's actually in the room going over homework with Ronan, and there's a lot of conversation about doing homework, and it's every time you see on the video that there is something that Ronan did wrong, whether it was impersonating a teacher at school or lying to somebody or lying to a teacher or those types of things, then the consequence you see on the video is that's when he got something taken away from him or he got in some way punished. And then he acts out again, of course, as a result of that punishment. And it's very sad to see how he reacts to that, of course, but that doesn't change the fact that the jury and the court has the evidence in terms of the audio as to why that conduct happened. It was not for no purpose or malicious purpose. It was for an educational purpose.
All right, so with respect to the aggravated child abuse count, without justification, is it your position that applies to each and all of the different avenues which can be traversed in order to arrive at a conclusion of aggravated child abuse? Because the reason I ask it the way I'm asking it is, a couple of the avenues require great bodily harm, and I do have the question for both sides to address as to what, because there was evidence of mental injury. I don't believe there was any evidence of any great bodily harm. So the question is does any kind of mental injury rise to the level of where under the law it is considered to be great bodily harm? That's first question. But this is the part of the information in terms of one of the prongs or one of the avenues that I want you to address specifically, and that is willfully tortured, maliciously punished, or willfully and unlawfully caged. And that does not require great bodily harm. And what I've just stated to you are the elements of aggravated child abuse following that avenue. And address that, because it seems to me that on that basis alone, I should be denying your motion for a JOA on count one, because there's at least one avenue that jumps out at the court that clearly a jury would be the proper entity to decide, the issues in this case because of where the evidence stands at this point.
So interestingly, the jury instructions don't give us a definition of caged and whether it's temporal or not. And two things I would point out factually to the court. One is many, many times when the door closed in the video, you don't hear a lock. So the door isn't locked on many occasions. So Ronan could open the door and walk out, just like anyone can in any room, and therefore those definitely would not fit the term of that level of confinement that one would say would be synonymous with the Webster's dictionary version of caged. There are times where he is, but there's a temporal aspect to that. And we heard it from, I believe it was Officer Lowe.
Let me ask, was there one time in any video that was played by the state where the victim walked out of the room without the parents opening the door first? I don't recall seeing a single instance of where that occurred.
That is true, but that's different because the door not being locked would not, in the terms of confinement under the law, in terms of like other types of cases or kidnapping cases or people being cuffed to things, you can decide not to go out. You can decide not to go out because there might be a consequence to going out and that you get in trouble because you weren't supposed to go out.
But why wouldn't that be a basis for confinement under the law where you have great fear that if you come out, bad things will happen to you? To me, is there anything in the case law that gives guidance on, because I'm not sure I agree with your argument that it wasn't locked, but that would be up for the jury to decide. But the legal point that you're raising for me is whether confinement actually requires a lock or confinement be achieved by virtue of the inducement of fear in the victim. So the victim is scared to death to come out.
So the difference in this particular set of circumstances, and the case law does say, I mean, not on cage per se, but on child abuses, and you just read it, Judge, it's very fact specific. So we're dealing with the facts here, which is parent-child, right? Parent-child in a situation where at times children get punished. If I send my daughter to her room and say, you're confined, you're not going anywhere tonight, you're staying in your room all night, I'll see you in the morning. It's not that she is confined in terms of caged under the law. She's not supposed to come out. Doesn't mean she can't come out. That is not a crime. That is not something where this court would find I committed child abuse. So I think there's a difference because of the circumstances between the two parties here, father, son. And clearly, as you can see in the video, every instance is tied to something that Ronan has done. He's admitted that on the stand.
But are you making the argument there that just because there might have been a legitimate purpose in the punishment, that a parent can never exceed, going back to the language used in the Tucker case, or excuse me, the Tate case, that where the punishment exceeds the permissible bounds of what is proper? To me, that presupposes there can be a motivation or a legitimate reason that started the punishment per se, but that punishment can go off the rails and exceed what is permissible in any reasonable society. I mean, you're not making that argument, are you?
No.
All right.
Of course, it could. And again, and as the court
All right,
read,
so you just accepted that.
Yes.
So if you accept that, do you not agree then it becomes a jury question as to determine whether the punishment here, the specific punishment, crossed the bounds of what is proper in a society such that it could be aggravated child abuse? Because, I believe there's enough that they could define that the victim was unlawfully caged. And so if you concede that, doesn't it have to go to the jury to decide it?
so again, then we would say in every case that every case would then go to the jury, because it's a question of, do the facts meet the elements, right? And that's what I'm getting at, is that this specific set of facts.
Well, that is the question, but it also comes with a big proviso, provided at this stage the state gets the benefit of all favorable inferences. So when you want to refer to that room as a structure, a box, or a cage, they get the inference that, hey, it's a cage, and it demonstrates caging at this point, don't they?
Well, I think caging, so the issue is that since my reading of the jury instructions, that there isn't a definition of the word cage. So, what we're really looking at is, and by all accounts, it's a room, correct? The caging aspect, is my understanding, would be, just from Webster's version, is that it's locked and confined and you can't get out. The only sort of caging case that I think I found in the fourth was Blover State. Doesn't really apply because it's handcuffed and chained to something, kind of a case. And quite frankly, in that case, they said the district court held that the plain meaning of the term cage does not include the act of chaining or handcuffing, and therefore the state did not present a prima facie case. And that's Blover State, 993 Southern 2nd 540. I'm sorry, that's a second DCA case, not a fourth. I didn't find one in the fourth.
Right. So, Mr. Wade, because I do think you might have a meritorious argument that there's some aspects of count one that should be narrowed. And so I want to focus on that, because that, to me, is where the real legal issue here is. In all of the avenues that are available for aggravated child abuse under count one, you agree that there's some that do not require great bodily injury, correct? The one I just talked about does not require great bodily injury.
Correct.
All right, so is your motion such that you're moving for a JOA on certain aspects of count one where great bodily injury is a requirement, and in your view, the evidence that's been presented by the state fails to demonstrate great bodily harm? Because if that's your motion, there may be parts that I need to have a conversation with the state about, because I have questions and they will need to explain to me where the evidence is of great bodily harm, if great bodily harm does not include PTSD or any mental injury. And if it doesn't, then there may be a basis to narrow count one.
So it would be both. Obviously, I'm moving for all counts, but as I made the argument, it includes what.
Yeah, you're going to lose on, I'm just going to tell you up front, and you can make your argument for the record, you're going to lose on the willfully tortured, maliciously punished, or willfully or unlawfully caged. I would be denying that because I think it jumps out at me that there's enough evidence for that. But the others, I'm not so sure, which is why I want to focus on that, because that's where the bigger part of my effort needs to be focused on at this point, is if I have to narrow count one.
Fair. So my position on that, and obviously then I'll turn it over to the state, is that great bodily harm and permanent disfigurement, they are defined. Defined as great means great, as distinguished from slight, trivial, minor, or moderate, and as such does not include mere bruises.
But it's got to be bodily harm, right? Physical
Bodily harm.
harm to the tissue, to the bones, to the skin,
Correct.
those kinds of things. Mental injury does not fall within that category.
Not on reading of cases that I've been looking at.
Okay, so let me take you to the second avenue. It's kind of in the information as well. I marked it as number 2, the avenue. And that is that the defendant did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury. Now, that standing alone, you would lose because I think there's evidence of mental injury. But it looks to me like in that particular avenue that it carries with it the conjunction and that it still has to have or result in great bodily harm, permanent disability, or permanent disfigurement. Let me hear your comment on that as well, because I think you're making the argument that it applies, but I want to hear you say it so I can properly register it.
Yeah, it's a conjunctive. It's an and not an or. Yes, I agree with the court on that.
All right. Do you have any case law to where it's been interpreted that way? I mean, I think reading it, it makes me understand it that way, but it won't be the first time I've read a statute and there is an appellate case out there that interprets it in a way that I might not always have interpreted. Were any case?
I focused on the fourth, and I used Wheeler versus State. It's a 2016 case, 203 Southern 3rd 1007.
All right, and so the last avenue that's in the information, and that is did commit an aggravated battery upon RTF, a child contrary to Florida statute 827.03. By virtue of the aggravated battery, that presupposes and subsumes great bodily injury, doesn't it?
Yes, Judge.
And so just mental injury would not be enough to sustain that prong. You agree with that?
Yes.
All right. So I'm in agreement with a substantial portion of what your argument here is. I haven't heard the state yet, but I see where you're going with your argument. I've told you that I already disagree with you on the one avenue that talks about willfully tortured, maliciously punished, or willfully and unlawfully caged. Are you going to address count 2 or count 3 at this point, or is your motion only to address count 1?
Count 1, Judge.
Okay. All right. So let me turn it over to the state. And who's going to argue, Ms. Black? All right. So I've given you kind of a roadmap of some of the issues that I've already looked at, and I want you to address. And I saw you shaking your head back there when I was talking about the mental injury. You concede that mental injury does not constitute great bodily harm under the statute?
Yes, under the statute is not. We are not proceeding under 1A or 1E. We are going under the theories of 1B, 1C, and 1D.
Okay, so let me go through the information and then you can address it. The information says that, Christine and Timothy Farron are about December 28, 2021 to January 28, 2022. And I'm going to cut through what I don't have to read. Did knowingly, and this is what I consider the first avenue, did knowingly or willfully intentionally inflict physical or mental injury that resulted in great bodily harm, permanent disability, or permanent disfigurement to RTF, a child. Okay. That presupposes the infliction of physical or mental injury. I think you have both of those here. There was physical injury and there was mental injury. The physical injury doesn't necessarily mean great bodily injury, but there was physical injury and there was mental injury based on the evidence that I've received. But that carries with it the additional requirement under that avenue that it has to result in great bodily harm, permanent disability, or permanent disfigurement. So my question to you is the state pursuing a conviction under that prong? All right, so that settles that. the motion for JOA on that prong is granted. So that won't be presented to the jury. So let's go to the second avenue. Did an intentional act or actively encouraged another to do an act that resulted or could have reasonably been expected to result in physical or mental injury? Again, it's just like the first avenue. You've got the physical injury and you've got the mental injury, but you have that little word there, and it says did result in great bodily harm, permanent disability, or permanent disfigurement to RTF. Is the state pursuing a conviction under that avenue?
Can you give me 1 minute, Your Honor?
And you may want to address the word and what you think it means.
Your Honor, it seems like you are going off of the information, the charging document. We're going over the jury instructions as far as each of the elements of the count.
Well, but the information tracks the statute, doesn't it?
Yeah, Your Honor, we're not proceeding under that prong. However, as to the great bodily harm, however, the lesser of child abuse includes the portion of that without great bodily harm.
Without great, so,
You would be asking going forward on that.
right, right. I'm only dealing with the top level offense, and I'm ruling the way I am because of the absence of great bodily harm, but that does not negate the lesser included offense of child abuse, which doesn't require great bodily harm. So let me be clear on that. So based on that, deal with the and did result. Do you agree with at least the court's initial interpretation of that and Mr. Wahid's conclusion as well, that in that avenue, it requires that there also be great bodily injury?
Yes, if it says and, then it.
All right, so you're not pursuing that based on the evidence that the court received thus far. And then the third avenue, I've already ruled in your favor on that: willfully tortured, maliciously punished, or willfully and unlawfully caged, RTF, a child. That one you are pursuing, and I would think that that's the major brunt of the state's case in regard to count one. Am I correct on that?
Yes, Your Honor. And just to kind of address what defense said in their argument as far as Blow versus State, in that case, it did not. That they said that caging does not include chaining a child, but they did talk about how the caging aspect is a wire or bar box-like structure or a small restrictive.
Yeah, you don't need to spend any real time on that because I've sat through the hours of video as well. It can be up to these folks to determine if that's a cage or not. What I'm concluding is there's enough evidence for them to determine that it could be, so it's going to be up to them. And then the last one, which I consider to be the fourth avenue, is did commit an aggravated battery upon RTF. Do you agree that that presupposes great bodily harm, so you would not be pursuing the charges or a conviction under that avenue?
Correct. Okay,
so here's where we are with what will be presented to the jury if we get there after the presentation of the defense case in this matter. So count one, the motion for JOA is granted as to count one with respect to everything except the requirements in the avenue of willfully tortured, maliciously punished, or willfully and unlawfully caged, which, based on the court's conclusions as to the evidence up to this point, that would be presented to the jury to determine. That does not mean that the lesser included offense of child abuse will not be presented, because it will, because that does not include the element of great bodily harm, which is the primary impetus behind my rulings in narrowing down count one. So everybody with me on my rulings on count one? So I think I've covered everything I need to cover in terms of my rulings. Is there anything else, Mr. Wahid, that you would need me to address from the standpoint of your motion for JOA? Okay. Any clarification? Okay. All right. And the court will reiterate and reconfirm its prior rulings in regard to all of the motions and objections that Mr. Wahid and the defense have made during this proceeding. If that's what we're just renewing all of that so that they're the same ruling as before. Ms. Black, anything that you ask or need clarification from the court on as far as my ruling?
No, Your Honor.
Okay. All right. So at this time, Mr. Wahid, it's appropriate for me to ask before I bring the jury out is, do you intend to put on a defense? Yes, sir. All right. And have you made a decision at this stage as to whether your client intends to testify so that I can conduct the necessary colloquy?
I have some civilian witnesses and a doctor.
All right, so you want to do those witnesses before you make a decision as to whether your client will testify or not? Okay, all right, so that just means that I'll defer the colloquy for you, Mr. Farrader, until such time as we're at that point where you have to make a decision whether you're going to testify or not in your own behalf. You understand all that, sir? Okay, good. All right, so Mr. Wahid, I don't see Ms. Murad. We're, you want to take 10-minute recess before we start? All right, so we're going to be in recess for 10 minutes.
To remind you, I renewed my objection to, in light of the testimony to Kellen McCoy, who is the teacher, about the incident where he embarrassed his sister, as that is not an issue in dispute. It was disclosed by the child during his testimony, fully admitted to it, and to have an additional witness testify to the same event that is not in dispute would be cumulative, especially when it's a prior bad act of the victim.
Mr. Wahid, do you want to address that, or is that for Ms. Murad? Let's get you mic'd up over there. You're good.
Yes. So that incident results in a response from Farraders, which goes to part of our case, which is that they engaged the school. They took the time to listen and understand what happened and gather all the facts before doing any sort of response with Ronan. So going through that process that the Farraders went through goes to all of what we're saying, that their conduct is not malicious, that it is educational, that it is parental, and it drives directly to a parental defense.
Is she going to testify to anything else other than what was admitted by the victim on the stand?
Yes, she's going to testify to the fact that the Farraders engaged with her in the school and exactly what I just said.
And she's a teacher?
She's a teacher.
And Your Honor, if you'll recall, the child testified to those specifics, that there was a meeting, that his mom had a meeting, and that his dad came, and that he went into the room with the teacher, with the dad. All of the facts in which he's going to elicit have already been elicited without dispute.
Yeah, I'm going to deny the motion. I think the defense is entitled to call the witness because she may have a flavor that the victim himself didn't present, and so you're entitled to present your defense, and I'm going to allow that witness to testify. Consistent with the scope and the parameters that I've already set out many times already with my in limine rulings.
Understood.
Okay. All right, can you let the jury know it'll be 10 minutes, and then we'll start back up with the defense case. All right, court's in recess for 10 minutes.
Before we start defense, I emailed Your Honor's judicial assistant about the 2 witnesses that will testify by Zoom. We're going to do them first, so if you could just make sure they're there.
Let me pull up my email here.
Thank you. I emailed Ms. White directly, so it may not be there.
Well, she would send it to me, so let me just see if I've got it here. You sent it to Division Ladies and gentlemen of the jury, we have now, as you know, completed the state's portion of the case. The state has rested. And as I advised you at the very beginning, the defense has an opportunity to put on a defense if they wish. They will be calling witnesses, so we are now in that portion of the case called the defense's case. And with that, Mr. Waheed, does the defense have a witness to call?
Yes, Judge.
All right.
This time, the defense calls Kellen McCoy.
Okay. All right. Before we administer the oath to Ms. McCoy, this testimony is being conducted via Zoom by agreement of the parties. The witness will be sworn in. And again, you are to view and consider, listen to the testimony the same as you would if this person was sitting right here on the witness stand here. Everybody understand that? Okay. All right. So, ma'am, I'm going to go ahead and administer the oath. If you could raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right, Mr. Waheed, you may proceed.
All right. So, and it's a little weird. I'm not facing anywhere, but I'm actually facing the camera. So hopefully Ms. McCoy is looking at me as I ask the questions. Ms. McCoy, if for some reason through technology you don't hear what I say, please, ask me to repeat it. And of course, if I ask a question that doesn't make sense, which happens a lot, just go ahead and tell me to repeat that as well. Ms. McCoy, can you?
I think I'm going to make it easier on you. I'm going to switch the